is it enough to say, okay, you know what, let's just choose GDPR because that's probably the most stringent. We'll just do everything by that. We don't need to worry about all these other little regulations that are out there. But is that actually a safe legal viewpoint? Unfortunately not. I think that GDPR is based off of a framework of good privacy principles, so it is going to get you maybe 70, 80% of the way there, right? GDPR is good privacy practices that you should be doing. Unfortunately, the way a lot of our US legislation is being drafted, there's these unique carve-outs, there's these exceptions, there's requirements that are sort of tweaked and slightly different than what you see in like the GDPR context. So you do need to be aware of very state-specific requirements as it stands right now because the states are dominating the conversation in the United States. You can't have privacy if you're not securing that data, securing that infrastructure. So you really have to have both of them go hand in hand together. And at XPAN, we help clients to better understand the legal liabilities that attach to the data that they're collecting, how they're using that data, the third parties that have access to or are being transferred that data, and then how they're setting up their network infrastructure and how they're securing that information. Our goal is to get clients to understand the legal liabilities that they may have, how they can transfer those liabilities, either contractually or through insurance, and then for the liabilities they can't transfer, how do we mitigate the risk in the event that we have a breach, a privacy incident, or even in today's world, an individual comes to us and say, hey, what data do you have? Right now we have liability even in that own, like what might have seemed like a simple question has now become a much more complex question. So we like to think of ourselves as spanning that gap between legal and technology and helping to translate what's required from a legal side into what has to happen from a technological side. Do you think, well, just give me an idea of what are you seeing as far as courts and the way they're holding companies responsible or not for privacy and security violations? So the court atmosphere right now is really interesting because we have historically seen a challenge in cases going forward because of the standing doctrine. Now, standing is a constitutional requirement for every case. You have to show that you have the right to be in front of the court. And as part of that right, it has been that you have to show that you've had an injury, you've had damages. And in the cyber context, it's been very hard to show damages because I could have my identity stolen today or I could have it stolen in 20 years. But if it hasn't been stolen, the future harm is not enough to get you standing in court. Now we're starting to see that change because judges are seeing that this is really an unfair outcome for a lot of data subjects. And so what we're starting to see is that they're starting to create these common law doctrines that will allow the plaintiffs to get around standing. So a good example of that, since we're in Pennsylvania, is that Dittman versus UPC case that came out of the Pennsylvania Supreme Court last year has created a duty of care for employers to protect their employees' information. So now there's actually a right of action that employees can use if their information is stolen that they have provided to an employer. So that's one example of where we're starting to see this evolution of trying to get court cases to get past this standing requirement and allow plaintiffs to actually litigate the matters and to hold companies accountable.